It's Sunday, the 7th of March, 2021, and it's very early in the morning, not quite as early as it was when the two of us got up and started preparing for today's recordings. Mark, after the 5 videos that we did yesterday, we agreed that today we would call today's video a training session on common law, which includes quite a number of individual subjects. I think that we're both in agreement that there's many experts out there who are constantly talking about Magna Carta, talking about common law, Article 61, etc., etc., etc. Do they really understand common law? Do they understand really the principle of the strawman? Well, we're going to find out. So good morning, Mark, and over to you. Let's talk common law today.
Yeah, I mean, it's a huge thing. And I think I said yesterday, whenever people start telling me about the common law, the first thing I ask them is just explain what you mean by the common law. And then all of a sudden they're flabbergasted because they've actually never really thought of the question. So what I'm going to do is start at the beginning and look at law and where does lawful law come from, so to speak. So I'll start again like I did yesterday when I was saying about lawful governance. Okay. Lawful justice stems from the monarch's second promise, where the Archbishop of Canterbury asked, offered her to contract, and the contract is, will you to your power cause law and justice in mercy to be executed in all your judgments? To which Queen Elizabeth responded, I will. So she accepted the offer to contract. And so we've got the words there, law and justice, and mercy. Now, mercy directly relates to judgments. So law is one thing, and justice is the way that most people understand it, is what's fair and just. However, like we said yesterday, equity equals what's fair and just. Whereas justice, in this sense here, is the form of law. How will you deliver it? And then the other thing is, what is the law? So looking at the law and what people call common law, or seem to think common law actually is, it's about doing no harm, is about as far as most people can go. But basically, it stems back to when the Normans invaded England back in the 11th century, and they were doing the land grab. So the common law precedent system, it used to be called stare decisis, which was introduced by Henry II in the 11th century. And that was basically let the decision stand. And today we know that as common law precedence, which is like I was saying yesterday or in the previous video. And if anybody in authority comes up to you and asks or you to do something and claims the authority from an act of parliament, all you simply do is turn around to him and say, sorry, that's an act of parliament. Please give me the common law precedence, because that's the law, or the law of the land. So with this land grab, basically, in order to justify stealing people's land, once they had a few decisions from the court, then they were retraining people to say, oh no, this is our justice system, and this is what it says. You know, in that case, your neighbor lost the land, okay, and therefore you must lose your land and I'll take ownership of it. Moving forward then into the 16th century is when things changed with Lord Ellesmere, who introduced the conscience into it. Because one of the problems that there was that depending on which side of the bed the judge got out of, you never knew how they were going to rule. So he brought in basically equity, but under the name of consciousness. People's conscience. So to provide mercy in all judgments from then the 16th century included the conscience, equity. So, like I said yesterday, this actually is a legal obligation of the courts as well. In the Senior Courts Act 1981, Section 49. And I think I said as well, basically the part of the selling of the justice system to people is, it goes back to the ruling by Jessel, who was at the time Master of the Rolls in 1878, where he said, this court is not, as I have often said, a court of conscience, but a court of law. However, like I've just explained, this changed already in the 1600s, but this here is one of the biggest marketing ploys that they use in the justice system. So we've seen that it's about letting the decisions stand and equity, about conscience. So if we start then with just first the basics of the rule of law, and with that, it's we need to look for the truth, because like I was saying, the truth is, the law is what consistently gives us the same results. And with that, it starts off with, how do we're born into this world, and we're gifted a mind by the Creator, and we're gifted a body by the Creator. So my mind owns my body is derived from the equitable concept that equity sees the true owner as the beneficiary. Our mind benefits from the body to be able to explore this planet beyond survival instinct. Survival instinct, the Creator still retains control of our bodies, and thereafter it's up to us to use our minds to explore it. So lawful excuse in equity is always argued with the state of the mind. So if your actions are survival instinct, and survival instinct is self-defense, shelter, food, water, air, any of those things that you need for survival, lawful excuse, you can argue in equity. So I've sort of made this little saying, which you've heard many, many times. It doesn't matter what you believe, when you choose to step over the edge of the cliff, the truth will prevail. And from that, we can all observe it. It's not like somebody's just telling you it. You can experiment, observe, experience this yourself. And that gives consistent results. And so from that, we get the unalienable lawful human rights as they are. These are universal law. These are from the Creator. It doesn't matter what you believe. Ignorance of law is no excuse if you step over the cliff edge. Nature will do its thing. The Creator will do its thing. So all of these, there's 6 of them, and they all stem from the truth, which is observable to anyone. So this is the whole basis of the law in common. So ignorance is no excuse. Ignorance of the law is no excuse. To lie is to go against the mind. All are equal under the law. No one is above the law. The law operates without fear or favor, and you're innocent until proven guilty. Everything will apply to you from the universal law until you hit the bottom. So anybody can test this. People have heard, especially now with this COVID-19 thing, about the precautionary principle. So if we apply the precautionary principle to the cliff edge, at the cliff edge, you can look over the edge, you can take a stone and drop it over the edge. You can take anything and drop it over the edge and decide for yourself then, oh, hang on, it's only a 4-foot cliff, I can manage this. or it's a 40-foot cliff and forget it, I'm not going to do it. But the precautionary principle is, before we rush in and jump over the cliff edge, we've got to be sensible and reasonable about it. And that is what allegedly has been done with this COVID-19. From these 6 basic laws, which I've just spoken about, to lie is to go against the mind. That's talking about a meeting of the minds. And when there's no consent, i.e. if somebody's lying, they are committing fraud. They are taking advantage of you. They're trying to benefit from you by withholding what could be critical information. All are equal under the law very simply means no privileges. So yesterday we saw in Edinburgh, okay, the police were coming up to the people and saying, oh, you should be at home.
Just before we discuss Edinburgh, Mark, just to let you know, you've got quite a lot of background noise. I think you've left the door open.
No, and, the factory's running.
Okay, mate. I wasn't sure whether or not the door was open or not.
Yeah.
Yeah. Rather interestingly, just sticking with Edinburgh, we'll come on to that because we want to talk about that a little bit of detail, don't we? As you say, is that one of the first people to arrive at Edinburgh yesterday put a post on Facebook, which I saw. As you know, I can't comment at the moment because I'm banned, saying that there was already quite a large gathering of police even before the people attended. So we know that there were 6 arrests that were made, and we're going to offer our services to support these people in the fact that they were treated unfairly, unlawfully, unjustly. And we'll take that back to them. So yeah, sorry I interrupted you, Mark. Yeah, back to you.
But the point with that, all are equal under the law, no privileges. The police were coming up and saying, oh, you got to stay at home. What are you doing out here? If it's the law, why are the police there? So if I've got to stay at home, so do they. End of. Honestly, it's as simple as that. No one's above the law, which means no immunity. Everybody's accountable for the harm caused. The law operates without fear or favor, due process or the rule of law, and innocent until proven guilty. And this, like I said yesterday, is the basis of what we're doing different. The claimant must prove their case, and we are innocent until proven guilty. So these are the fundamental things which most people actually know. However, the question becomes, how on earth do we have that enforced? Because the rule of law includes enforcing these basic concepts which we've just gone through. And that there fundamentally, what I've talked about so far is what most people would probably call the common law. It's definitely law in common, which is observable and experienceable by anybody, and therefore it's definitely testable and in common. So, like I said, the monarch, she, through the promises, creates a contract to provide the service to uphold the law and justice and provide mercy in all judgments. So the law is what I've just established, observable to everybody, and justice is the system of getting the rule of law, and mercy in judgments is found in equity. So now we'll just look at the justice system, and common law precedence basically is the search or the existing status of the search of truth based upon conscience. So the conscience is what you argue lawful excuse from existing precedents. So the existing precedence is what is called the law of the land, or is the law of the land. It's enforceable in the courts, and it's enforceable over everybody. And the Boris Johnson case in 2019, now a lot of people say this is a political case. However, I believe It was well ruled, in that it reaffirmed the rule of law. What it's saying is the courts are the ultimate dispute settlers in the country. And they brought up and reaffirmed precedences which go back many hundreds of years. And it applies, again, what I've just said with the law. What is the law? Nobody's above the law, everybody's equal under the law, and all, the basic concepts. So I just want to read a few excerpts from this, just to show you this actually exists. It's a unanimous 11-judge Supreme Court judgment. And any judge below, in the courts lower, if he wants to turn this over, he's a very brave person or a very stupid judge. So in the Boris Johnson judgments, and these are what they've quoted, it's all in there. The king hath no prerogative, but that which the law of the land allows him. So that is affirming the people, or what you were saying yesterday, how does the governance derive its authority? It's actually in the courts and nothing to do with voting or democracy. This is where we get our remedy. Further, it goes on, indicating that the limits of the prerogative powers were set by law and were determined by the courts. The courts have exercised a supervisory jurisdiction over the decisions of the executive for centuries. This is nothing new. And it goes on then to say the government are accountable to Parliament for what they do so far as regards efficiency and policy. And of that, Parliament is the only judge. However, it continues then, they are responsible to a court of justice for the lawfulness of what they do. And of that, the court is the only judge. And then it goes on to say, the Secretary of State could not order searches of private property without the authority conferred by an act of Parliament or the common law. So it's telling you, it doesn't matter who you are in the country, and you are accountable in the courts to one another. So it's incredibly powerful judgment. Like I say, it's tremendous that it's reinforced the route to reintroduce the rule of law. And what's interesting about it, again, is we've yesterday touched on the judgment of Matt Hancock and Boris Johnson, that they acted unlawfully. So I think what I've just shown you, there's the judgment that says these guys must be held to account. So the obvious question is, why on earth is nobody in the government, in the legal system, or the Attorney General, the Lord Chief Justice, the Crown Prosecution Service, why on earth have they not brought these people to justice? The courts have ruled that it's unlawful what they've done. And this is where what we're proposing to do, in the absence of them doing it, and the reason is obvious why they won't do it. Basically, Boris Johnson's the head, he's the Prime Minister, and I'm sorry, he'll just sack the Lord Chancellor if he wants. And these guys are probably reliant, dependent on their jobs for whatever reason, but they're not prepared to risk their jobs. And this is where this comes in, what we're doing. It's about where they fail to do what they meant to be doing, then we have the same powers as the Crown Prosecution Service individually. And we can take Matt Hancock or Boris Johnson to court and hold them to account in the court, as opposed to in Parliament. And the other question, which is very obvious, which needs raising here, is why on earth are Parliament not holding them to account? In the first case, they should be holding them to account long before it comes into a court. So hopefully that gives you an overview of the creation and the process of common law, and what is law and how is lawful justice supposed to be implemented. That's probably as simple as I can really get it, but it's about binding precedences. Anybody comes to you and says, Act of Parliament, you simply turn around to them and you ask them, please provide me the binding precedents. That's what they use in the courts.
Just a few comments that I've noted down on the back of that, Mark. Interestingly, isn't it? I put here that people automatically make a few assumptions, which is, first of all, going back to, as you were saying, is what actually is common law. The general people just turn around and say, I stand under common law, I do not consent, which is absolutely fine. That is a statement. It's a true statement. I stand under common law.
Going back to those 7 things.
And I do not consent. What we're trying to say is that there's a difference now. People should now be in a position to say, I understand common law, and I understand why I can say to you that I do not consent.
Exactly,
because
and that's called standing.
The attitude as well is another note I've made here is stop treating the police or any form of judicial system as a higher authority. You yourself are the highest authority, which is what the point you're making now, which is we as men and women and human beings, is we are going to make these people accountable for what they've done. It's interesting, isn't it? I think the mindset of most people is the minute that you mention common law, or as you say, don't call it common law. I think it's better now to start calling it law in common, because the minute that you mention common law, people automatically, again, and this is very clever down to the word system again, isn't it? Is that I'm just a commoner. And therefore, the interpretation of being a commoner means that you are no one. The monarch is everything, and you are just a commoner. On the contrary, you know, you are a creation of the Creator. And the Queen is there actually to serve you and to ensure that in serving you, that there is a parliament in place. And that parliament are the people that should be acting responsibly on behalf of the people. And as you say, it should be parliament that's actually serving the notices straight out to the people that's actually operating within government, because they're all acting illegally and unlawfully.
Yeah. And I think probably with that, it's important maybe to reiterate that, because the monarch's promise, the promises, the contracts to govern, if I just read the first 2, Madam, is your Majesty willing to take the oath? I am willing. Will you solemnly promise and swear to govern the peoples of, and then it goes through the list, according to their respective laws and customs? I solemnly promise so do. Oh, sorry, so to do. Then the Archbishop asked, will you, to your power, cause law and justice in mercy to be executed in all your judgments? To which she accepts the offer to contract, I will. Do you hear there anything that says the superior, that we inferior? It's on an equal basis here. And so the whole, like you say, the wordplay is very, very clear. And I think I started using the word law in common as opposed to common law, because actually when people use the word common law, most of them, or at least many of them, do understand that it's case law, but it's actually called common law precedence. So common law is a very, like you say, you know, be psychological commoners.
Absolutely.
But like the Supreme Court ruled, yeah, we're all commoners. Doesn't matter if you're the Prime Minister, if you're the monarch, we're all commoners. So,
Mark, I think that's a good place to close today. And I'll finish by reminding people as well is that don't forget these acts that have been mentioned are being produced by actors, aren't they?
Correct.
Good.
And actually with that, Glenn, what are they doing in the whole coronation ceremony? All dressed up, acting, theatre.
Yeah.
What are the police? Dressed up, acting, theatre. In the courts, dressed up, acting, theatre. It's all about acting. It's a play. So,
well, we don't have time for this one today, but I think, as you know, if we did actually, you and I, take a walk through certain coronations and courts and churches, etc., you might actually start seeing with your eyes wide open now exactly what's going on in there. Thanks, Mark. Catch you on the next.
Speak later, Glenn.
Talk to you later.
Okay. Bye.